Aloha and welcome. I am Mark Alexander, Executive Director of the Hawaii Medical Association. Thank you for joining us for today's Conversations at HMA, a program which features discussions with physicians and other thought leaders in the healthcare arena. For this edition, we are pleased to have a members-only special presentation with HMA Attorney Clarence Kekina, who will summarize and comment on the recent ruling by Third Circuit Court Judge Robert S. Kim in the Nitta versus HMSA court case. Before introducing our guest, I want to review the format for our program. We'll begin with a presentation by Clay Kekina, which will last for about 30 minutes. After his presentation, we will move to the question and answer part of our program. You are invited to submit questions throughout this program by using the Zoom Q&A function. Please type in your questions, comments, suggestions, ideas throughout, and we will feature as many as possible after the presentation. You should have received 3 attachments earlier today: an outline for tonight's presentation, copies of key legal documents, and a general resource packet. These are resources that will be referenced tonight and also will be helpful for your own follow-up. We will end this program promptly by 6:30 p.m. We want to hear from you. Please email info@hawaiimedicalassociation.org or contact us via our website, hawaiimedicalassociation.org. It is now my pleasure to introduce our speaker. Clarence Clay Kekina concentrates his law practice in the areas of business, contract, real estate, insurance coverage, and litigation. He received his bachelor's degree from the University of California at Irvine and his JD from Loyola Law in Los Angeles. He served as law clerk to the Honorable Simeon R. Atoba in 1994 and the Honorable Sandra A. Sims in 94 and 1995. Mr. Kekina is admitted to practice law in the state and federal courts of Hawaii. Without further ado, we welcome Clarence Clay Kekina.
And thank you for that introduction, Mark, and for having me here for this conversation about this Nitta versus Hawaii HSMA case. As you know, Mark, we've been following this case because you had asked me even before this decision that came out recently was issued. This case is it's a very interesting case, and I wanted to explain. Like, I gave the handouts. I'm not going to go into detail for all the handouts, but what they are is I thought they would be very informative to the members of HMA, and I will explain how they're relevant to this discussion. So this case in the Third Circuit, it touches on, I think, a lot of important issues that affect physicians, not just here in Hawaii, but throughout the nation. It's an ongoing issue as far as how physicians are able to practice medicine. And in this case, as stated in my summary, and if you read the findings of fact, conclusions of law, and opinion that was given by Judge Robert Kim, essentially what happens in this case is it's going up on appeal on the issue of the judge found that the contracts, 3 different agreements by HMSA were adhesion contracts and unconscionable. And because of that finding, the judge essentially was saying that HMSA could not enforce the contract. And the issue that was presented that HMSA is focusing on is they had moved the case into arbitration. And the plaintiff's attorney in this case didn't want that. He wants this to be heard by a jury because of what happened, to his patient. Although Dr. Nitta is the named plaintiff in the case, there's another doctor that was also involved, and one of his patients was hurt by the way that the way they're saying that HMSA contracts operate. in this case, Dr. Nitta's patient was a lady by the name of Charlene Orsino, and she essentially was denied coverage or pre-authorization certification for medication that she needed because it would help her not go into early, like into labor too early. And in fact, because of the delay in getting that prescription, she did go into labor or she suffered problems. And my understanding in reading the case and reading the findings is that her child actually, suffered an injury from that, some sort of mental damage or anything. We don't know the details of that because the case actually doesn't get into all the medical evidence. And it focuses more on, the analysis of the contract and what happened and why, these benefits were denied. For the other person, the other patient, his name was Scott Norton, and he was denied coverage for, my understanding and reading it is he presented to the physician. He had certain kinds of pains. The physician assessed that, hey, I don't know what's going on. You need an MRI. Puts in the request for the MRI, and he gets denied the MRI. And HMSA only approved the physical therapy. He goes to the physical therapy, his condition gets worse. So at this point, he has to get something. They don't know what's going on. He gets an MRI, but time has passed and it's discovered he had cancer. Now, I don't know, again, the facts underlying, is this a delay of diagnosis case? That's not clear. But the presumption is that that delay in care hurt his condition. And it didn't coincide with, what the physician was recommending. And that's where we get to the core issue, right? Like who is really dictating treatment here? And so the fight in these contested hearings, and one of the things that's not in my outline that I wanted to point out in looking at the history of the case is that initially the case was either removed or, HMSA took it to federal court. Now, why do companies do that? Corporations often feel that they're going to have a better chance of prevailing in federal court because they don't want to be in the state court and your state court juries. And federal court operates differently. The federal court dismissed it, saying, hey, we don't have jurisdiction over this issue, remanded it back to the circuit court. And that's where we get to, these proceedings that occurred in front of Judge Robert Kim. Motions for summary judgment were filed by both sides. And essentially, HMSA's motion was a motion to compel arbitration. And I did have the chance to speak to both HMSA's attorney, wasn't a long conversation, and the plaintiff's attorney, Ted Hong, prior to this conversation. So I have some insight as to their view of the case. What I gathered from HMSA's attorney is they're viewing it very narrowly, and they're focused on the arbitration clause. And from their point of view, the judge is wrong. Because the judge found that the contracts were, one, adhesion contracts, and two, they were unconscionable. Now, those two terms kind of go hand in hand. Like I remember back in law school, the basic definition of an adhesion contract is, it's your standard form contract. It's a situation where you have two parties and one party drafted the contract. The other party had no real say as to what language or terms go into the contract. I think one of the best examples I can give is like a lease. Most of the terms in a lease are standard. There's some that you can write in, but there's very little negotiating on the terms, maybe the amount of the rent, but the terms of the contract are what they are. Another version is if you have Microsoft Word or any computer program, you have these end user license agreements, which you click accept on. Those are adhesion contracts. Now, the important thing with an adhesion contract is that they're accepted in business and the law in the sense that generally they are enforceable. But if the adhesion contract is also found to be unconscionable, then the court can rule that it's the contract, either the specific clause is not enforceable, or they can extend it to the whole contract being unenforceable, which is what happened in this case. And I think HMSA's view right now is it's not unconscionable. It's an arbitration clause. These are in all contracts. And it's fair. There's no bias here. And they take the position that we always are willing to negotiate with physicians. But in listening to what the plaintiffs have to say, they presented evidence that my understanding is 15 or 16 declarations from various physicians were submitted as evidence, all stating in simple terms that they had no say and no negotiating power for their contracts with HMSA. And the case does point out that they focused on three types of agreements: the HMSA participating physician agreement, the HMSA provider agreement for Medicare plans, and the Quest participating physician agreement. I think in my experience, like, I'm more familiar with problems arising with the participating physician agreement. And I think that's the agreement that members of HMA and other physicians will want to know, like, how does it affect those agreements? Because what Judge Kim found is, when he examined the evidence, is that the process did not allow the physicians any real meaningful bargaining. You know, HMSA does send out letters when agreements come up, you know, when they're ending, and they say, hey, you know, we want to talk to you about it. If you have any input, you know, we'd like to discuss, you know, if you're okay with the agreement. And the evidence showed that pretty much all the physicians said, yeah, they meet with us, but we don't really have any say. And, you know, I would throw it out, you know, like, I don't know what all the collective experience of physicians are. I think it's going to differ. And that's, you know, I've been thinking a lot about this because I've been as I mentioned at the beginning of this conversation, you know, when Mark first asked me to look at this case, it hadn't reached decision yet. But HMA was aware of it, and I think some members were calling like, hey, should we do what Dr. Nitta is doing? And my advice at that time, and it still kind of continues until this comes to a conclusion, is you have to be careful. You know, I don't know that you want to, you know, do that, because it's hard to say what's going to happen right now. Because at the end of the day, you have to deal with HMSA in Hawaii. They, you know, it's what, 50, 60, 70% of patients are going to come from them, you know, or be insured by them. So what do you do as a physician? And what concerns doctors, I think, in this is where, when I was preparing for this conversation, you know, I thought it important to include the legal documents. And what I included was the findings of fact, conclusions of law that Dr. Kim signed off on, and which is the current order in place and which is going up on appeal. I also included the complaint and the 3 exhibits attached to the complaint that was filed. I think if you want to read all these things, the complaint goes into a little bit more detail on the underlying facts. So it's important to you know, or it might be enlightening to read that. And it also has the agreements that Dr. Nitta had. I also included other materials that I thought were pertinent to this discussion, because when Mark asked me about this, I know that for physicians, I think, you know, there's two things at issue here. One of them isn't really covered in the facts of the HMSA Nitta case. The one issue here is, like, what the court found. The reason he found it unconscionable is he found that what HMS agreements did is they undercut the physician's ability to direct treatment, and it interfered with that physician-patient relationship. And because physicians didn't really have a meaningful say in what services are approved and not approved, the judge found, you know, that's part of the, you know, factual analysis he has, that this is unconscionable. It's not fair. It's not right. And in this case, the court didn't just find the arbitration clause unconscionable. He just said the contract is unconscionable. So to focus only on the arbitration clause at this stage is not correct, right? Because the whole contract is unconscionable. It's going to be interesting to see what the appellate court does. Are they going to go with HMSA's view and focus and say, hey, this is a wrong decision. The arbitration clause is not unconscionable. It's okay, and the court shouldn't did ruled like it did and should have let it go to arbitration. Or is the court going to agree and say, hey, it is unconscionable? And if it goes, or is it going to do something else where it's in the middle, right, and send it back for further findings, right? Let it litigate in the trial court more. We don't know. We don't know what's going to happen at this stage. And so that, that gets into, like, for physicians, I think, when you're looking at these participating agreements, like, you want to know these things, like, and there's a lot of things to know, like what say do you have in what's a covered service, right? Like, how do you know what is a covered service? You don't, I'm pretty sure you guys don't get trained on that in medical school, right? That's a legal type of term, right? It's a coverage issue. And the thing about it, the thing when you're dealing with insurance coverage is you meet with somebody, right? And who are you talking to, right? It's a representative of HMSA. Do they really know coverage? It's not clear to me, right? Like, it could be the people that are selling, it could be a director who doesn't really know the policy, because coverage issues come up in different ways. Now, the other issue that I think is important to physicians that's not really covered is how you get paid, right? The payor payee dynamic, which is inherent into these participating agreements. And I think something that is constantly being reviewed, and this is something to me that is a national issue, right? Is the term, I believe, is a capitated payment. What is the capitated payment rate for physicians? Now, in 2019, my understanding is HMSA changed their payment method, and they went to this fixed capitated payment where, depending on your practice, they're going to give you a rate like $24 a patient. No matter how many patients you see, that's what you're going to get paid. Okay, and it's up to you as the physician to provide treatment, the value of treatment, and not to go over that. And because if it goes over that, you're kind of losing money in your business. So if you can keep it under, your business is doing better. But in addition to that, their system, as I understand it, created a lot of administrative tasks for physicians, which force physicians don't have time to do that. Not everyone is a wizard at this tech stuff, and it's not easy to understand. So what happens is physicians are forced to hire additional administrative staff. Now, is it working? I personally, it's something I'm tracking, and I also included that 2020 in Paradise in Hawaii. I found this, and it's a fascinating article, and it assesses after about 1 year or a little bit more than 1 year from the implementation of HMSA's, payment transformation system. And that study concludes that the majority of physicians are not happy with it because they feel that they're spending too much time with this administrative task or incurring too much cost that's not fair to them. Now, I'm not personally, I don't know fully what the dynamic is right now, but I'm sure this is a concern for all physicians. And part of the problem I have with the whole system is that it's just not transparent, and I think it should be, or maybe there's a business reason for it not to be, but I don't really see it. I think it should be known what the rates are, because it's really not fair to physicians in small practices. They have less bargaining power, less ability to get a good capitated payment or payment rate. Now, I think if you talk to HMSA, they will say differently, but what the real truth is, I think that comes from individual experience. So the other thing that, I wanted to touch on is what should you as a physician do? Does this Nitta case change how you negotiate your agreements? It does in some sense, but it doesn't in some sense, right? What do I mean by that? Like, it's not, it's up on appeal. So what HMSA is gonna say right now is in this particular case, under these particular set of facts, hey, judge ruled that our contract's unconscionable. We don't agree with that. Okay. So they're gonna look at your contract still on an individual basis. Maybe you have some leverage, hard to say right now. But that kind of, how much time do I have left?
Yeah, no, please take whatever time you need to present. Yeah, you're only 15 minutes into your part.
Okay. The pay or payee dynamic, the way it relates to the HMSA decision in my mind is because the court found that the agreements were unconscionable. What the court looked at is, and I think the court took into consideration the evidence presented from the declarations of physicians saying, hey, we don't feel we have a say in this process. So I think this is where it's important, and this is where I think an organization like HMA is so valuable, is today it's real easy to be out there and just stuck in your own business and worried about that and not having the time to really worry about the big picture or these kinds of issues that are going on. And it's important that you come as a collective to the degree you can. It gives you more leverage to negotiate. Now, HMA can't negotiate for physicians, but they can, as an organization, we have a collaborative relationship with HMSA. And, we have physicians from all the different categories, from, presidents of the large groups like HPH to solo physicians. And when you come together and you have the same agenda, it helps a lot. And that's where I think it's important for physicians to participate and be involved. And it doesn't take a lot of time, just giving your thoughts or letting the organization know what is your experience, what's going on with you, right? Because there's no, I don't believe the physician participating agreements. And if I'm wrong, you gotta let me know. But I don't think there's like a confidentiality clause that says you can't share, certain things with other physicians. And if it does have that, that's something you should object to, because otherwise you're just going to be left in the dark and you're not going to know what's going on and how you can better position yourself for a better agreement. Because right now, the insurance companies have more leverage because they're more organized. And they're not split in their view. They know what they're doing on all the contracts. Whereas if I'm physician A, I don't know what physician B is doing unless I talk to them and they're willing to talk to me. And they might not be. Maybe it's a competitive thing. I don't know. But these are things that I think are developing. And across the nation, you're gonna see this issue framed in different ways. Like I read these things like seems to be a push to one payment system, and that's a political thing, but this is a dynamic of that. But I think what's important is, I think overall HMSA is a good organization, and I think they have the community's interests at heart. But I think it's a business, so they're going to operate like a business, and it's an insurance company. So they're organized and they draft these contracts. They got their lawyers advocating their position. The clauses favor them. And to what degree a physician can change any particular clause it's very difficult for some of them. But I think for physicians to be viable today, this relationship with HMSA, it has to improve. And physicians have to be a part of the conversation. I don't think they have been. Like when HMSA did this payment transformation, I'm unclear on what, say, any medical practices had in it. You know, or was it just something they wrote out and this is what it is? I think you can opt out and do it under the old payment system. I'm not as familiar with how that operates. Like, what does that mean if you don't choose to be in the payment transformation system? But the other thing too, I think that is constantly changing is the coding, right? Like they make these decisions on what is a covered service. And that's not fully discussed in the case. But if you read between the lines, that's what's at play. When a patient is recommended by their physician to get an MRI, right? I'm pretty sure there's a certain code that goes with that. And then they're gonna look at, well, okay, well, why are they asking for an MRI? What's the problem? And the facts I gathered from reading the Norton matter is he just presented with pain. So whoever the insurance side adjuster is or claims person, they just said, pain? He doesn't need an MRI, just go get massage and physical therapy, you know? And and I get that, I mean, that's logical, but they're not the physician. And that's the problem. Who is making the decision? Who has the real authority? And it should be the physician. And it's not. So hopefully, when the Supreme Court or Intermediate Court of Appeals comes back with their decision, it will give us more clear guidance on how to interpret these contracts. And it will give room for physicians to be more involved in that patient, physician and care decision making. Yeah, I could open up for questions now. That kind of covers the summary.
Okay, all right. No, thank you very much, Clay, for that summary. I'm going to ask a few questions that have come in already. First one is kind of a logistical one, practical one, and that is, what is the expected timeline and what's the process? Like, okay, it's going to go to the appellate level now, and then once a decision is made there, I think the next level is what that it goes to this.
I believe this case went to the Intermediate Court of Appeals. Because I would have to double check that, though. I don't know exactly. I think it went to the ICA. If it goes to the ICA, you're gonna get an ICA decision, right? And then the appellant and appellee, if they disagree with the ICA's decision, they could request review by the Supreme Court, which isn't guaranteed. I don't know how to give a percentage. It's not very high. It has to be, the Supreme Court's only gonna look at it if they feel it's a new area, it's an area of law that needs, a decision, like it's new and it hasn't been reviewed before. The process, I'm not fully up on that. I would say on average, it takes 2 years to get an ICA decision, maybe a year. They get to it fast because they are moving a little faster, and then Supreme Court, same kind of time frame. So if it went directly to the Supreme Court, which I don't think it did in this case, I didn't check to ask that. Supreme Court decision probably comes out in 2-3 years.
So we can expect, say, if this goes to the next level, the intermediate, then it's going to be probably a couple years before decision, and then after that,
Couple years, 18 months to 2 years,
Right.
could be longer to get backed up.
Okay, thank you. The next question is, you mentioned that this case has the potential of having impact, not just here in Hawaii, but beyond. Could you say a little bit more about that?
Oh, what I meant by that is it's getting a lot of media attention already. And I think the reason for it is the judge was pretty strong in his language. And if you check nationally, right, like HMSA is part of Blue Shield, Blue Cross,
Blue Shield.
so these issues come up in other states. So, the way the law works is we're not presidential law in other states per se, but still other states can look to other out-of-state decisions for guidance or point to it as evidence. So I think, claimants across the country are gonna review their particular situation and their agreement, especially if they're in that situation where they've been denied treatment. And same for physicians, if they feel that their patients aren't being fairly treated, and it's because of the nature of these insurance agreements. Because the other thing, I didn't discuss this because this gets into a lot of details, but one of the other things that the plaintiff's attorney did in framing the issue is he noted that when Dr. Nitta gets a patient, he has the patient sign an agreement with him. And what that agreement essentially says is that if there's any payment that's owed to me that's not covered by insurance, you, my patient, you agree that you're gonna pay me, you're gonna take care of me, I get paid. And that's fair. I think the patients understand that, and whether Dr. Nita actually enforces that or not, I don't get the sense that that's why he does it. He just does it to have this contractual relationship with the client, and it gives him the ability, if he needs to pursue payment, he can. What's discovered in this process is that HMSA's participating physician agreements has a clause that invalidates that agreement. And so that was another factor that Judge Kim agreed that is another interference with the physician-patient relationship. You can't do that. That's not fair. And what the participating physician agreement says is it just says you can't do that, physician. You only get paid what we pay you. So that puts physicians in a tough position again, right? Because now you're back into this box with the insurance company, where there's an incentive for you to not recommend treatment. And, I think feelings are going to differ on that, depending on who the physician is, depending on what the particular injury is, who the patient is. There's a lot of factors. But at the end of the day, I think, you go to medical school, you're the professional here. You're the one that makes these medical decisions. You should be the one to determine that, or at least have a big say in it. I get the insurance, what the insurance companies will say, well, we can't let them do that, and the costs are just gonna skyrocket, and insurance will become unaffordable. I guess there's some validity to that, so the insurance company has to put some rein on what's recommended, otherwise treatment might run amok, as they say. But that's not the issue going on right now. I think that might have been an issue 30, 40 years ago. But today, insurance companies, the way the system is, they got a lock on all this. And you are in a box, whether you like it or not, and it's getting more and more complex as time goes forward. The codes get more complicated, and it depends on the specialty. So that's kind of one of the things. And so I think this decision has impact beyond the state because it goes to these issues. Doesn't have any legal precedential value, but it does. I think it matters.
We have several other questions that have just come in. One is, I was asked by the state to return in very threatening terms over $20,000, as they said I was not a PCP. I am an OBGYN. And at the time, I was seeing patients as a PCP, no longer doing that, as I was trying to help out. So they're sharing their experience.
So PCP, just so that's
Primary care physician, right? Yeah.
And you said the state is that I'm gonna make an assumption, is that like a Quest participating physician agreement?
Yeah, whoever entered this question didn't indicate that.
So if it was, I'm not sure what the question is, but I understand sharing the experience. My thought on that would be, I'm not clear on the meaning of when they say you're not a primary care physician, you're an OB, so you have to return the money. I don't understand why. Is that something in the agreement that says you're not entitled to payment? So I'm not really clear on that dynamic, why you were asked to return the 20,000. So I don't know that I can really answer that question.
Okay. All right. And then someone else asked, on the subject of contracts and payment transformation, HMS sets the dollar value of the PMPM arbitrarily. On the mainland, the PMPM is close to 100, but here it is $20 to $30. How can individual physicians improve their PMP? Do we need to be a unionized body to speak with a stronger voice?
That is a very good question. And I don't think there's a very clear answer to that, but that's kind of what I was talking about. Is unionizing the way to go? Maybe, if you believe a union will do a collective bargaining agreement that increases that capitated rate, that PMPM rate. I'm not familiar with the percentage breakdown like that. In Hawaii, it's 30%, and the mainland, it's 100. I don't know about that because I believe in the mainland, they are experiencing the same thing. And I think it may differ from jurisdiction to jurisdiction, but these involve laws of all the states. And you got to remember, it's also impacted by federal law. Because my understanding, I don't know the numbers, but I do know that the community health centers, which were at a core part of, Obamacare and the Affordable Care Act, and it goes back to, I think, even back when Bill Clinton he envisioned these community healthcare centers to serve underserved populations. And they're popping up. I believe we have 7 or 8 in Hawaii. Those community health centers get a higher capitated rate. So they can open up across a medical practice, and those physicians are going to have a tough time competing with the community health center. The way they defeat that is they got to say, hey, we get better care because we're more specialized, we've been in the community longer, right? They have to present something. But in terms of monetary value, that's a federal law. The community health centers, they're just getting paid at a higher rate. And it's hard to compete with that. And then on top of that, you add in the fact that the private physicians negotiate different rates. And the questioner stated that here it's arbitrarily chosen by HMSA. Now, the Payment Transformation Act, I wouldn't say it's arbitrary. They did some kind of analysis on their part, and they concluded that, I believe the number I keep seeing is $24, right? You get a rate of $24. Now, I don't know if that is different depending on the physician. And I don't know exactly like how to explain how HMSA gets that number, but that's something that we need to figure out, like, or discuss. And are they transparent about that? I don't think they are being transparent.
So one note that came in from a practicing physician is that payment transformation is for capitation payment for primary care doctors only, for example, internists and pediatricians.
Okay. Is that so in that statement, see, and so these are the nuance, like I'm not familiar with that, but like the intricacy of that. So is that why the doctor who asked the original question as an OB wasn't entitled to that kind of payment, and maybe the 20,000 represented a capitated payment, and they weren't entitled to it? But it doesn't make sense to me that they would have to give all of it back, because if they did some kind of care, they should be entitled to some kind of payment, unless the agreements say if you're not a participating physician, you're entitled to no payment, right? And if that's the case, then that's something that needs to be looked at. I would recommend that individual get the agreement if they have one, and find out, and then if they didn't have one, how did they get the payment? Like, I'd look at that. You don't want them to accuse you of fraud, or that you misrepresented something to get that payment. That would worry me, so be careful with that.
Another comment on the union issue came in as follows. We as physicians have identified as a profession, not a trade union. So we end up speaking with an individual voice, not a strong collective voice. If we all join HMA as a unified Hawaii and profession, could this help change things with the HMSA policy?
I think it could. I don't think it would in the same way a union does. And that's a good point that you make as an attorney. I agree. We're a profession, so it's very hard for us to unionize. It just doesn't work the same. But it doesn't mean we can't share information, right? And so it's a catch-22, right? Maybe you're not going to share because you got a better ability to get a good deal for yourself. But if for physicians who know they don't really have that, and there's probably a lot of them, you guys should get together and say, hey, how can we approach HMSA, or whatever other insurance carrier is coming here to pay physicians, and work out a good agreement. And have more say in that, in changing those terms. Because what HMSA seems to do is they send these letters out, and they meet with you individually. They don't meet with you as a group, and they're negotiating with you, and they're prepared. When they walk into the room, they're prepared. They have their agenda set. And and it's hard. If you're in there by yourself, what can you do, right? Are you gonna say no and walk away, and then you don't get payments from HMSA? That'll kill your practice. So I think coming as a group, it should help, and I think it would help.
Someone noted that the question of unionization of physicians is the very hot topic nationally. PBS apparently had a segment on it recently as well, sharing information that came in. Another question, can this be approached through a line of logic that argues HMSA assumes a partial or full degree of responsibility if they deny coverage of a treatment or test?
That I don't think, I mean, that's not, that, I think what that question is getting to, and it's an interesting one, because when I read the case, the HMSA versus Nitta case, it struck me as, I practiced personal injury before, and that included, is this an underlying medical malpractice case, creating liability on the physician? I don't think that's what's at issue in these cases. I don't get that sense, not with the Nitta case. So if you're gonna, I don't think that's gonna happen in the sense of trying to shift that kind of liability to HMSA. In a sense, what you want to say is you in this kind of situation where their contract is found unconscionable, you're absolutely saying they're responsible because they made the decision to deny treatment. So you're already saying that. So that logic is already there, and that doesn't need to be changed. It just has to be pursued. But how do you pursue it? And Dr. Nitta's one of the people pursuing it. And it's kind of a unique case. It doesn't happen all the time because it's not easy to do. He put his practice at risk, I think. But when you look at the community, he serves the underserved community. So as you can tell, one of the agreements was a Quest participating physician agreement. A lot of private practice people try to move away from those kinds of agreements, right? I know this as a patient, right? Like doctors are choosy now who they take on as a patient, and it's hard, right? We don't have a lot of doctors in Hawaii, but it depends on what field too, right? There's some fields that there's enough. There's other fields that are really hurting. And it's just, and so as a physician, what you need to think about is absolutely you want HMSA to be responsible if they're the ones that are making the decision to deny coverage. The other thing too is these administrative tasks. I'll give you an example of when you're analyzing these clauses. One of the things you should be able to bargain is whose responsibility is it to do the administrative task? HMSA could do that. They could take that responsibility where they do all the administrative stuff. But if you read the contracts, it seems like the majority of them are shifting that burden to the physicians.
So kind of following up on that, another question that came in is with the prior authorization process, was this addressed in the case that when they did ask for approval, was it reviewed by a peer, a physician with the same kind of skill level, or was it reviewed by and denied by an administrator without that kind of educational equivalency?
That's a very good question. My read on it, it's unclear. I believe it was the administrative clerk without the professional background. I don't think it went to, a physician review. I didn't get that out of the facts. And in my conversations with the two attorneys, they didn't mention that. Yeah.
All right. How does this case affect the proposed HMSA Agilon routine testing management, in which patients are limited on how many laboratory tests can be done per year? For instance, a diabetic can only be tested for HbA1c twice a year if diabetes is controlled. This program is initiated to save money.
I don't know exactly how to answer that, but in analyzing it, what I would say is, if that sounds like a program within this payment transformation, right, where they're limiting the treatment to a set number. So where this case, and then I'm gonna assume that there's agreements that lock a particular medical practice that's giving these tests, into that number of treatments. If the physician in that practice determines, right, with a diabetic that, oh, this guy, he needs another test, what happens? Is it just automatically not covered? Is there any room for coverage? Because if there is, or there should be, to me, you as a physician, did you have any say in that? Like, that you should have some discretion to say, hey, there might be a situation where my patient needs more than two, and that should be at least partially covered or covered. I think this case affects that, because that gets into, that goes into the process. Like, how did you enter into that contract? Did you have any bargaining power? Did you have a say? If you didn't, you could point to this, you could use this case to renegotiate these contracts, right? Like, and just say, hey, HMSA, I got this, I got these patients and they really need more testing. And I think, and it adds evaluation for you as a physician. You gotta think about that now. Because as a physician, I would imagine you're always thinking what's best for your patients. It's not just about, it's the saving cost benefits your patients too, right? Because to the degree we save costs, keeps insurance coverage premium down, keeps treatment down, costs down. That's important, right? In US healthcare, I always analyze US healthcare. What we always think about from a big point of view is access, cost, and quality. And it's very difficult to have a policy that provides all three. I think you can have a policy that gives you two out of the three. And that's where you get different camps. But which do you want? Everybody gets access, everybody gets cheap costs, but the quality of care kind of goes down. Or you get great care, it costs a lot, but not everybody has access because it costs money. So it's a dynamic. It's hard to get all three. I haven't seen any real big picture policy that hits all that. That's my view. So,
Well, the analysis that you're giving links back to two key points that you made in your summary, and that is this case really affects the physician-patient relationship.
yes,
And it's around treatment decisions.
yes.
And so, however this case moves and gets ultimately decided, it will very likely impact those two areas, some of which have been brought up in the Q&A already.
Well, ideally it will. What it could also do is just avoid all that and rule on the arbitration clause. And just say, hey, the arbitration clause is not unconscionable. And then just send it back, go to arbitration, and then we won't hear about it, right? It's arbitration.
So let me push back, because the way the initial decision came down, as you said, it went well beyond just addressing the arbitration clause, which is what HMSA wanted the focus to be. It went well beyond that. Is it likely that the appeal and the Court of Appeal will ignore the fact that Judge Kim ruled beyond just the arbitration clause? In your experience, is it likely that they would ignore what is really the bulk of the judge's decision?
That's a good question. And the reason I'm pausing is you're asking me what the likelihood is. And
Yeah.
We have some new justices up there right now, right? There's been a change, like
Right.
the old guard is leaving, new guard. And I don't know the views of all the justices to be able to answer that. I don't know. And then I don't know what they're gonna be thinking about, because, if they issue the decision and it does, they're gonna think about how is it gonna impact all the all the agreements. So I don't know what they're gonna do. But I think in my mind, it's a 50, right? I see both sides, but I'm hoping that they address it. Because I think, you know, Ted Hong and Dr. Nita, they presented a good set of facts for the court to consider, I think. Um, what the particular justices who issue the decision do, it's not easy to predict.
Right. Thank you. Another comment that came in, it is rumored that HPH and QMC negotiate higher PMP, uh, PMPM for their employed PCP than the PCPs in private practice. That might speak to the power of the negotiator and a lack of transparency of HMSA. Is that possible?
I agree. I think it's possible. I think that's true.
Yeah.
I think that's absolutely true statement.
All right. And then someone asked, who's the representing attorney for Dr. Nita again?
Oh, Dr. Nita's attorney is Ted Hong.
Ted Hong.
The HMSA attorney is can't say his name, but he's with Cox and Frick. It's Robert Wadoff or something. I don't know how to pronounce his name.
All right. A couple other comments that came in, and just to be transparent, make sure we're fully participatory. In number, there is strength that 20 to 30% of doctors refuse to agree with HMSA. Perhaps they will listen.
Yeah, I think so.
Mhm.
I think they're gonna listen, and more important, I think they may bargain, right? They may give some concession, or let the doctors be more involved in the process.
As you know, Clay, HMSA shared their agreement with HMA asking for comments. And my understanding is we're the only medical society in the country where an insurance company has actually done that. Do you see that as an entree for perhaps getting even more input from our physicians to HMSA?
Yeah, absolutely, and it would help if we get comments or something that you could show, because that doesn't it's a process, right? Like,
Right.
and it's an ongoing thing, and so, and that's where this dialogue came in. I was Mark had asked, or you got a call from HMSA, right?
Yes.
To see if they heard about this conversation, and they wanted to know if I'd be willing to speak to their attorney. And I told Mark, yeah, definitely, I would like that, because it would give me added insight into what actually happened. And unfortunately, their in-house counsel didn't call me. He referred it out to the counsel that handled the case. And I say unfortunately is, I really wanted to talk to the in-house counsel, because I wanted to bring up this point, like, hey, we've already talked to you, or at least I know HMA's leadership has talked to you guys, but we're getting our membership, we're growing, and we're getting more involved. What latitude is there here? Because the feedback we're getting is, you guys say you negotiate, but all the physicians are telling us they got no say. And so they're getting very frustrated. And HMA as an organization, our concern is about the community. How do we get doctors here, and how do we keep them here? It's getting harder and harder to do that. So you throw these kinds of things in there, it doesn't help.
I think that the fact that you were able to access attorneys for both sides indicates the important role that HMA can play as a quote unquote more neutral party with a very clear agenda. We're advocating for our physicians, their patients, and public health.
That's a good point, because I think both sides were willing to talk to me. Whereas normally I think you would get hesitancy from at least one side. Like, usually the HMSA side wouldn't want to talk, because it's it's, I guess, proprietary business type of thing. I think they're beginning to see that they have to do something, and hopefully that extends to other jurisdictions. That's again where I think what happens here can affect other areas. And you got to remember, even though it's really easy, I think people to think, why we're so small, we're out here. But when you think about Hawaii, we're actually at the forefront of a lot of things, in my opinion, right? For instance, nationwide, Obamacare was a big deal. To me, Hawaii's had Obamacare for 30 years, right? So, we've had that. And so Obamacare didn't really change anything in Hawaii. I mean, it did, but, it didn't, we already had the prepaid healthcare act. So that's just one example. And I think our medical community here has so many great physicians, and it's changing. I think the business side of being a doctor is so much more complicated today. I think when I was in college, even, I think it was feasible for a doctor to be a hometown type of physician, even here in Honolulu. But I don't think that's really possible right now. It's very difficult.
Speaking of finances, another question came in. Did the issue of financial transparency come up in this court case?
No, that wasn't one of the issues, right? Like, that's not one of the core issues, the financial transparency. It was more focused on the patient process. But I think, and that's why when I first looked at this, I think that's what the physicians as a whole, they're gonna care about that. But the decision making in the case affects that. Because, the patient physician process, right, where the insurance company or the administrator is dictating treatment, that too has to be transparent. When they try to shut down doctors, or they tell doctors you can't tell other doctors about that, that's wrong. I think it's wrong. And this case kind of brings that out, and at least, whether you agree with Dr. Nitta's practice and how he does things, he's kind of old school, he's kind of tough, right? But he had an agenda here, and it, to me, has a positive impact on the community. And so I think it should be looked at in that way. And the thought process should be, we're not trying to destroy HMSA here. We're just trying to be part of the process. And we want that, in order for physicians to better serve the community, but in order to do that, they got to be able to take care of their own practice. And when you throw in all these hurdles they got to go through, it's almost like, why would you want to be a doctor, at this point? Like, you're making it impossible to practice medicine. And that's what you went into it for, is to practice medicine, to help people, and you get paid for that. You deserve to get paid for it. To be a doctor now, it's amazing to me how much time you have to put in before you're actually practicing.
Well, thank you so much, Clay. And as this case progresses, we look forward to continuing this conversation with you, and really appreciate, the insight that you've been able to bring to the conversation, and your willingness to, engage with the attorneys, and engage especially with our physicians and our physician members and some community members that were present tonight.
Oh, my
Thank
pleasure,
you.
Mark.
Thank you.
Anytime.
So we are coming now to a close, and I want to say more formally, mahalo to all of you for joining us for this edition of Conversations at HMA. We're especially grateful to Attorney Clay Kekina, and for all of you participation tonight. We know you have your choice of activities, so we thank you for spending some of your time this evening with us. This program and the attachments will be made available to HMA members by early next week via the members only Member Tidbits webpage on the HMA website. Again, we encourage physicians to be active members of HMA. It facilitates and makes possible programs like this that specifically serve the needs of our physicians. Once again, mahalo, and have a great week and weekend.